What's good? This your main correspondent, Alan Taylor, and I'm back in the broadcast room yet again, always with another one. So apparently, be honest with you, man. Yes, I haven't covered this Young Thug trial at all. I'm talking about at all. Um, of course, just it was okay, but Jesus Christ, I just wasn't necessarily into it like that. But the thing of it is, what I'm saying, this trial has been going on for quite some time now. Now, I have been seeing it go across my feed and stuff like that for a long time now. This is a very long trial for some reason. And so apparently recently here, Young Thug's lawyer found out some very interesting information. And he called it out in the middle of the courtroom, and it was about the judge, and the judge was doing something that he really didn't have no business doing. So, what we're going to do here now, we're going to go here and we're going to put the, also on this segment here, we're also going to hear from the lawyer we're going to hear from Young Thug's lawyer's attorney. So, yeah, let's put these quarters, nickels, and dimes in on the times.
Jeanette Levy, and this is Crime Fix. It was a crazy, wild day in court in Young Thug's trial. On Monday, it started with testimony from Kenneth Copeland, who goes by Little Woody. Copeland wasn't really into testifying, despite being given immunity by the prosecution. He spent the weekend in jail after refusing to testify on Friday. Copeland took the stand on Monday and let it be known that he wasn't going to do it.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Find your footage and get the perfect.
So he immediately pleading the fifth. Damn, okay.
And Steele let the court know that he found out that Judge Earl Glanville, prosecutors, and Copeland with his lawyer met in chambers without members of the defense teams, including Steele, present.
I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment.
So can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Now, this seems really unusual that a judge would be meeting in chambers with a state's witness and the prosecutor without a member of the defense team there. But Judge Glanville was furious that Steele found out about the meeting in chambers.
So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir? I'm going to hold you in contempt if you don't tell me who this. Tell me who this information was coming from.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not answering
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I am telling you.
I tell you what, I'm going to give you 5 minutes. If you don't tell me,
don't have to.
If you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me. You got 5 minutes.
Glanville actually ordered that Steele be thrown out of court for the day over Steele's objection and the objection of his co-counsel.
Well, I'm going to hold you in contempt, and you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea
I have
may
an
be
idea how
wrong.
you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not going
Sir,
to
I
breach
don't
that
want to.
confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
You
I'm the one who
cannot
raised it.
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in
Don't you-
time.
The prosecutor on the case, Adrian Love, said there was nothing improper about what happened with this ex parte meeting in chambers regarding Kenneth Copeland being held in contempt.
We certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive.
Now, it seems like even the prosecutor thought that this could be an issue. Adrian Love asked that Steele be allowed to return to the courtroom.
We would ask that the court fashion a punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels. For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this trial.
Now, later in the day, and I mean the evening after 7 p.m., attorney Ashley Merchant came to court to represent Brian Steele in this contempt matter.
Judge, just for the record, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to tell, order the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was.
Okay.
Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So
There we go. Alleged conversations. Or if it alleged, but he has too much details. But the conversations is alleged. Okay. I mean, we all know what alleged means. That's neither here nor there. So, he's not trying to actually say that he was there, but then he can't, he's not trying to deny it either. So, yeah, this is ridiculous right here. This is ridiculous. And now, I'm not a lawyer, so I don't know 100% technically how this is supposed to go. But I don't think that he was supposed to be talking to whoever he was talking to in those chambers without the defense lawyer being there as well.
Oh.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
Well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
If you're anything like me, you are always cleaning up a mess, especially with pets and kids around the house. Land, and it's worth got rid of Blue Land
Hold
with
on.
water. Plus,
I didn't know this shit was gonna pop up in
If you could imagine your ideal way of working,
Yeah. You got a commercial.
% off your first order by
Okay.
Still hold you in summary criminal contempt pursuant to OCGA 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated in the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court.
Now, after the judge said that Brian Steele was going to have to spend his weekends in jail, Steele had just one request.
Can I ask a question?
Sure.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, sir, if that comes to pass, you have my support. I will talk with our sheriff and we may be able to make that work. Okay.
And this entire thing has turned Brian Steele into a hero of sorts among defense attorneys. Joining me is Ashley Merchant. She is Brian Steele's lawyer. She's also the president of the Georgia Association of Criminal Defense Lawyers. So Ashley, talk to me a little bit about how you end up at the Fulton County Courthouse last night at 7:30 at night, representing Brian Steele in this issue, this contempt matter.
Definitely not how I imagined my day beginning or ending.
Right.
I was in a meeting and my paralegal came in and said, your phone is lighting up and Brian's in custody. And I said, oh my God, call me on my phone. I'm getting in the car. I'm driving down there. And, you know, I've served for many years as GACTL, as our association's contempt attorney, where we have attorneys that we dispatch if any lawyers are ever held in contempt. We call it Strike Force. So I'm a member of that. So I'm one of the lawyers that regularly would represent someone. But when I heard Brian was in custody, I had to go myself. And luckily, he's very loved in our community. And so many members of our team went down there and were there. And so we had a very strong showing of force, but it was definitely something I did not expect to happen.
You're a criminal defense attorney and you've done a lot of murder trials. Is this unusual? Because it sounds unusual to me that a judge would meet in chambers with a prosecution, you know, the star witness for the prosecution, the star witness's lawyer, and they'd all be.
Hey, hold up a second here. Okay, so the judge, hold on here. Okay, so the judge wearing earrings out here. Hey, yo, he thugged out. Okay. Just had to point that out a little bit. Yeah, you know what I'm saying? He thugged out in there. Okay, then. We got you, Judge.
The star witness's lawyer, and they'd all be there having a confab together without a member of the defense team present. Is that weird? That seems like an ex parte communication or something.
Right. And, you know, during my hearing, the judge is admitting that he had this ex parte communication. And it seems like that should be what everyone's focused on, not whether or not Brian is going to tell him who told him the judge had this ex parte. It just seemed like deflecting. You know, the judge was in trouble, got caught with having this ex parte hearing.
Okay. So, like I said now, like I said, I'm not a lawyer. I'm not in the legal system at all. But I did find this interesting because at the end of the day, I just had this inkling that, you know, a judge would, you know, at this particular point in this case, I didn't think that he was allowed to do such things like this. And of course, come to find out, he's not able to do this. This is crazy right here. So you mean to tell me they just doing whatever they want to do out there in Georgia? So down there in Georgia, you got Fanny out there shaking her fanny all over the damn place. You got this guy right here on the bench doing whatever he want to do. Man, it just seemed like Georgia's legal system just all fucked up right now.
So what the French toast is there to think about? You can't make this shit up.
You can't make this shit up. It seems like they legal system screwed up out there, and it's on camera. The whole nine. The lead DA on camera acting the ass. This judge on camera doing shady ass shit out here. Man, come on, bro. Come on, bro.
And instead of admit to that and handle that, you know, when Brian brought it up, they're going to throw Brian in jail. It didn't make a lot of sense. But like you said, it's unheard of. These proceedings are supposed to be what we call adversary, where all the defense is there. The defendants, the defense lawyers are all supposed to be present. But instead, they chose to have this meeting without inviting any of the defense, without letting them know. And when they brought that up, the lawyer ends up in custody.
The only time I've ever heard of a defense attorney maybe being back in chambers meeting with a judge without the prosecution present or something like that happening is when it was like, oh, judge, we need to talk to you about funds we need allocated for an expert or something like that. If it's like a public defender case or something, you know, that's the only time I've heard of this type of thing happening. But this just sounds hinky. So what are you doing for Brian now? Because Brian, as of right now, is supposed to report to the jail Friday night to spend his weekend in the cell with Young Thug, getting ready for court and doing his time for this contempt that you argued.
Lord have mercy. Yeah, they're gonna commercial me, but hey, though, this is crazy out here.
Serving.
Right. I mean, there's two huge issues there. The first, what we're doing is we are appealing it. So we're filing an emergency appeal. Thank God we have an emergency process in Georgia to appeal contempt orders. We believe the judges of the appellate courts will grant a bond. And so hopefully Brian will not have to spend his weekend in the jail. The worst part, though, is this trial is continuing. And so imagine, you know, we don't just work during the hours you see us in court. When we're in court, we are regularly working after hours. We're working at night. We're working on weekends. I have never tried a case where I didn't work all weekend. And Brian is a very good lawyer and he does a lot of work on his cases. So he's definitely working all weekend. You're taking a man from his office where he has computers, Westlaw, internet, all this stuff, access to the case file. And this case file's huge, and putting him in a jail cell where he's none of that. That the trial can't continue. I mean, it's just, it boggles my mind that anybody thinks that you could have the lead defense lawyer in custody the entire weekend and this trial continue unhinged. That defies logic to me.
So I'm wondering if at the end of the day, due to the fact that the decision that the judge made to confide with this situation in his chambers, the chain reaction of this, will the chain reaction of this actually be allowing Young Thug to will this be a escape on this trial? Will this trial be just totally dismantled because of what the judge pulled? I'm asking a question here.
So what the French toast is there to think about?
You know, and I know it's legal terms, you know, legal words and stuff like that for actually what's going on here. Of course, like I said, I'm not a lawyer, so I don't know the actual legal terms, but in, you know, the best of my abilities, at the end of the day, you know, I think this is like an acquittal or some shit like that. You know, it just makes no sense. You know, you as the judge, you're meeting with people secretly, technically, you know, that you're not supposed to be meeting with within a criminal trial that you're trying as a judge. And, you know, once you get outed, you know, basically in the middle of the courtroom, that's what he was really pissed about, that he got outed in the middle of the damn courtroom, you know, which it kind of is what it is. Now you feel some type of way and you think that, you know, because you have the power at that moment, and that's true, he had the power, you're going to hold the lead lawyer in contempt of court because he won't tell you the name of the person that actually, you know, gave you the information about you meeting with this individual in the secret, you know. Okay. You know, I don't know. It seems like lately Georgia's law system is up to no good. I mean, I don't know what's going on out there in Georgia, but, you know, you got all these Negroes out there high on power, drunk off power and shit. You know, man, stop it, bro.
So you're filing the emergency appeal. I mean, I would assume you expect to hear back about that within a day or so. Am I wrong about that, or what's the process? What's the time frame?
Yes. Luckily in Georgia, when an attorney is subject to incarceration, the appellate courts respond very quickly. And what it's called is a supersedious bond. So essentially they issue a bond that kind of stays everything and says, wait, hold on, we're going to pause this. You're not going to have to go to custody. You get to go and do this appeal. And so it just pauses that while the appeal is pending. If we're successful with the appeal, then Brian never has to go into custody. Obviously, if we lose the appeal, he could still be forced to spend weekends in custody, but that would be down the road. That wouldn't be right now.
But then we have the issue of this big kerfuffle. I mean, this big mess, this big confrontation between the judge who, who seems very angry and really dug in on his position, and Brian Steele. Now the trial continues and they have to move forward. Brian Steele moved for a mistrial. That's not happening. Can this trial continue in your view and be tried fairly given what's happened? I mean, it doesn't matter if the jury didn't see this. It's something that is impacting the course of the trial.
I can tell you as a defense lawyer, nothing will affect your advocacy more than a judge saying, if you keep arguing and doing your job, I'm going to lock you up and putting you in handcuffs. Nothing will affect you more. And that's essentially what happened. Brian made an argument. He ended up in handcuffs. He ended up in the Fulton County Jail in the lockup for, an hour or so before the judge let him out. Nothing will stop an advocate in their tracks more than going to jail, because you can't do your job. And that fear has got to be in the back of everybody's mind in that courtroom. Every single defense lawyer, some of them, they may have kids they've got to go home to and they can't go to jail. I mean, you think about the things that are going on in their minds. You want to be able to do everything you can for your client, but you can't do that if you're in jail.
But Ashley, can he go to the appellate court? Can Brian Steele maybe go to the appellate court and say, look at what happened? I mean, it's on video. That's not how appellate courts make decisions, but it could be filed as an exhibit and
right.
file something saying this is, some type of an appeal saying what is going on here, what happened is impacting this trial. Can that happen?
Oh, yes, definitely. And I was doing some research this morning working on this appeal, and the law is really clear. If you have an ex parte communication with a witness during trial, it is reversible error. So this error is, and what that means in the legal world is that's about as bad as it gets. That means it's reversible. That means that any conviction is going to be reversed because of this. So if they want to try and remedy this, they better hurry up and remedy it. And the state should really be thinking about that, because the state's duty is to preserve their conviction. So if they were to get a conviction, they have a duty to make sure that the conviction stands on appeal. And this is reversible error. So
Hey, yo.
Hey, what's the French toast is there to think about?
Okay. So we've just heard this from Young Thug's attorney's lawyer. Okay. The fact that at the end of the day, what the judge did, he pulled a foul move, basically. So they could technically throw this whole thing out of court against Young Thug because he pulled that move. And then, he pulled the second move when he actually started locking up Young Thug's attorney. This is all screwed up here. This is all screwed up. So, from what she's saying, from what the attorney of Young Thug is saying, they can really throw this out. And if they decide to come back on it, they can throw it out again because of that error. Man, wow. Okay. No, listen, look, man. He should have really thought about this before he pulled that move in the private chambers and stuff like that, but obviously it's people around that are willing to, kind of, reveal private information like that. And that's what you get when you run around here trying to be sneaky and shit. I mean,
Hey, what's the French toast is there to think about?
That's what you get. Man. Georgia getting a lot of bad stigma here lately on their legal system. Like, seriously. And obviously they're not paying attention to this. Georgia is getting a lot of bad press on their legal system here. This is the second part of them getting bad press right now. You know, the lead DA was the first. Now we got this judge right here holding secret meetings with people that he had no business talking to without everybody present. And now it's like, what the fuck? Man, come on, bro. Come on, bro. Yeah. But it is what it is, though, man. Hey, shout out to all my subscribers out there. Mad love to y'all. If you're new to the channel, please hit that like, share, subscribe button. Make sure that you ring that bell, that you'll be notified whenever I decide to post things. And like I always say, oh, my bad, right here.
And that, my friends, is the bottom line.
That, my friends, is the bottom line.